Wow. Just wow. You're not going to believe what the dissenting judges said about the majority judges in the Bianchi case and what they said about the anti-gun movement within the Fourth Circuit Court of Appeals. A shocking revelation that just shows the dirty pool that this channel, the Four Boxes Diner, speculated in detail what was happening in the Fourth Circuit has now been revealed. And yes, indeed, the games that were getting played within the Fourth Circuit to shut down the Second Amendment have now been revealed to all of us. Let's talk about it when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed, What the 10-7 Attacks Teach Americans About the Right to Bear Arms. Check it out on Amazon if you don't already have a copy. And by the way, for those of you going to be down in Knoxville, Tennessee in a week or so at the Gun Owners of America convention, I look forward to meeting you all there. I'll be speaking and doing a book signing, so it'll be a big weekend for me down there in Knoxville, and I'm very much looking forward to attending the first ever convention of the Gun Owners of America. All right, folks, so shocking news. I referenced this in my prior video about the Bianchi decision by the United States Court of Appeals for the Fourth Circuit, which is the court that covers, for example, Maryland and Virginia. The Bianchi case, as you probably recall, deals with Maryland's quote-unquote assault weapon ban of semi-automatic rifles. And the Fourth Circuit Court of Appeals heard this case en banc, which means that all the judges in the Fourth Circuit heard the case and issued a split decision, but the majority found that the semi-automatic rifle ban in Maryland was constitutional under the Second Amendment. The dissent said this is clearly wrong and misapplies long-standing Supreme Court precedent, including the Heller case, and that there's no way that semi-automatic rifles like AR-15s, AK-47s, and the like can possibly be banned under Supreme Court precedent, which is undeniably the correct answer, which we've talked about extensively on this channel. And I'm highly confident that the United States Supreme Court 100% agrees with my view, because my view is the Supreme Court's view is my best guess. And we'll see whether or not the Supreme Court takes the Bianchi case next term, the 2024-2025 term. I think there's a very good chance that will occur, but only time will tell for certain. We'll see what happens. But the reason why I wanted to shoot this video specifically is something I promised you, is in the past, I have flagged what I consider to be judicial misbehavior against the Second Amendment. Now, it's very difficult for ordinary Americans to flag this kind of behavior because you need to be kind of inside the belly of the beast, if you will. And because of my expertise and experience in big law firm law and high-level litigation and things involving federal judges and the like across the country for many years, I have a feel for what's going on with the court system that many people do not have, just by virtue of my long experience all across the country handling major cases as a Wall Street litigator. So when I said to you many months ago that I thought that there was a game being played within the United States Court of Appeals for the Fourth Circuit down there in Virginia, based on some of the things that were going on, I felt highly confident, but I could not know for certain because the evidence was not available to me, because what courts do is obviously confidential, and if you're not in the court, you're not going to know exactly what's going on, even if your speculation is reasonably good. Well, it turns out that my speculation that anti-gun judges within the Court of Appeals for the Fourth Circuit were playing games against our constitutional rights, my speculation has now been proven to be absolutely true. How do we know this? I'm sure you all read this to your children last night. Footnote number 2 on page 87 of the Bianchi decision, which goes on for 180 pages, because I'm sure you all wanted to read this in extreme detail, and you probably caught this. Because who wouldn't want to read footnote number 2 on page 87 of the Bianchi decision by the Fourth Circuit? Anyway, this is really shocking. So what I'm going to do is I'm going to read this to you, and I'm going to explain to you what this means, and just what kind of, in my opinion, dirty pool was played here against our constitutional right, a constitutional right to keep and bear arms. Let's read what this footnote says, and then I'll break it down as to why, to me, it's utterly shocking and borderline scummy in my professional views and my opinion based on what is said here. Now, before I go to the graphic and show you what the court said, I want to remind you what happened here. The Bianchi decision had previously been up on appeal in the Fourth Circuit. It had gone up on cert. And then what happened is in June of 2022, and these dates are very important, in June of 2022, the U.S. Supreme Court issued the Bruin decision, which really did not impact AR bans, but nevertheless, as part of what the court usually does, if there's any possibility that a Supreme Court decision could implicate another case in a particular subject matter area, such as the Second Amendment, they will GVR it back to the lower courts for the lower courts to take the first review to see if there's anything different about what happened here. Happens all the time, standard practice. So in June 2022, the U.S. Supreme Court decides the Bruin decision, dealing with, of course, text, burden shifting, history, and so on. You all know that. They then took the pending en banc, the pending decision, the pending case of Bianchi and sent it back down to the Fourth Circuit and says, hey, let us know if you're going to redo it or what you think about our decision in Bruin. It doesn't impact your case. They did that for a bunch of cases. And then this is what happened. The Fourth Circuit panel, 3-judge panel, keep in mind, 3-judge panel, ordered the parties to provide supplemental briefing. And then, listen very carefully to the timing here, because the timing is important. On December 6th, 2022, hear what I just said? June 2022, Bruin's decided. December 6th, 2022, less than 6 months later, like 6 months later, okay? There's oral argument in the Bianchi case in front of 3 judges, okay? Then what happens is we wake up, and a year later, in November 2023, I do a video, as I recall, that says, what the hell is going on with the Fourth Circuit? Why are they sitting on this easy case dealing with semi-automatic rifle bans? Are they going to do something with dirty pool, in my view, and somehow grant en banc review on the grounds that they don't want a 2-to-1 decision to come out in favor of the Second Amendment? I shot that video, I think, and released, I think, in November, December 2023, going like, why is it taking a year to decide this very easy case involving AR-15 bans out of Maryland? Well, lo and behold, shortly thereafter, the U.S. Court of Appeals for the Fourth Circuit issued their decision that says we're not going to issue a decision now on the Second Amendment. Instead, we're going to hear this case en banc, which delayed the case even further. Keep in mind, Bruin is June 2022. Oral argument in Bianchi and thrown at 3 judges is December 2022. November, December 2023. A year later, I do a video saying, what the hell is going on? Shortly thereafter, after I flag this issue, the Fourth Circuit Court of Appeals issues a decision that says we want to hear this case en banc. Then on March 20th, 2024, they hear oral argument en banc, and today, here we are, right, in the middle of the summer 2024, they have now decided this case of Bianchi. Well, why did it take so long for the court to hear this case and issue a Second Amendment ruling? Well, it turns out my speculation was correct, which is there were games being played by anti-gun judges to screw the Second Amendment within the Court of Appeals for the Fourth Circuit. Literally. Here is what the dissent writes about exactly this terrible situation within the court. The dissent writes, quote, "This unorthodox procedural posture bears some explanation. After hearing the case in December 2022, the initial panel majority reached a decision and promptly circulated a draft opinion. Yet for more than a year," did you hear what I just said, folks? "Yet for more than a year, no dissent was circulated. The panel thus held the proposed opinion in accordance with our custom that majority and dissenting opinions be published together. 1 year later, a year later, as the proposed opinion sat idle, a different panel heard arguments in United States versus Price, which also involved interpreting and applying Bruin. The Price panel quickly circulated a unanimous opinion that reached a conclusion at odds with the Bianchi's majority's year-old proposed opinion. Facing two competing proposed published opinions, the court declined to let the earlier circulated opinion control. Rather, in January 2024, we invoked the once extraordinary mechanism of an initial en banc review. And the court goes on to say, I hope that we will not find ourselves in the posture again soon, suggesting that the majority opinions may be issued without awaiting dissenting opinions to prohibit those dissenting judges or dissenting opinions from exercising a pocket veto to deny or delay fairness and justice. Now, let me cut to the chase what that means. In December 2022, 6 months after Bruin, a 2-1 decision in favor of the Second Amendment that was going to hold that AR-15 bans and semi-automatic rifle bans were unconstitutional under the Second Amendment was going to issue by a major court, the Fourth Circuit Court of Appeals down there in Virginia and Maryland. That was going to be a massive Second Amendment victory. An opinion had already been written in December of 2022 in our favor, in support of the Second Amendment, as well it should have. And the dissenting judge in that case chose on purpose to not write a dissenting opinion and circulate it to her colleagues. Instead, the judge sat on it for over a year to ensure that another Second Amendment decision by the Fourth Circuit would be issued, knowing that the panel in that other Fourth Circuit opinion, that other Fourth Circuit case of U.S. versus Price, was going to write a 3-0 unanimous decision against the right to keep and bear arms. And after that occurred, the entire Fourth Circuit, rather than allowing the Bianchi 2-1 victory for the Second Amendment to be issued, quashed it, killed it, prevented it from being made public, and instead granted en banc review, which gave rise to the Second Amendment loss in Bianchi en banc. So even though it may turn out that the U.S. Supreme Court is going to take advantage of these games by the Fourth Circuit, and it may ultimately be to our favor for this to have occurred, the reality was that in December 2022, well over a year ago, we had a major Second Amendment victory that had been written by a 2-1 Court of Appeals panel saying you cannot ban AR-15s in America because they're in common use. Almost certainly that's what the opinion was going to say, because that's what the dissent says here in the Bianchi case. And instead of that seeing the light of day and being a legal precedent that other courts across the country could use in favor of vindicating our Second Amendment rights, that draft opinion by those two judges was buried by the dissenting judge with effectively exercised veto power over that, and then it was further buried by the entire Court of Appeals for the Fourth Circuit. Absolutely pathetic, unprofessional, and in my opinion, scummy. But if you're an anti-gunner in America, if you don't care about the Constitution, if you don't respect it, if you think that being a judge is about political advocacy, which so many people on the left do, who view the court system as just one more super legislature to make sure that we, the people, are forced to live under the world in which they envision when we, the people, don't vote for it. If we vote for it, they applaud it and say, good job, we, the people, we agree. If we vote against it, they use the courts historically to impose their will on us, such as with gay marriage, when everyone in America basically didn't want gay marriage. There was constant laws, federal laws, and so on. And nevertheless, the Supreme Court, in that case 5-4, said that gay marriage was a constitutional right. And I'm not saying gay marriage is good or bad. It's not the point I'm making. The point is that these judges that do not respect the Constitution simply will do whatever it takes to win for their side. And this behavior described in footnote number 2 on page 87 of Bianchi illustrates the point. Now, the good news, I'm going to give you the silver lining here. Many years ago, you did not have the benefit of the Four Boxes Diner and someone like me, right? Someone like myself, to be able to flag these issues when they pop up. Because this is the sort of thing that will never be reported in the New York Times. No one writing in the modern press will catch any of this. And if they do catch it, they're not going to flag it. But that world does not exist for the anti-gunners anymore in America. Because this is the sort of thing that I will catch. Footnote 2 on a 180-page opinion will be caught by Mark Smith, and I will bring it to your attention. So even though you may not be a lawyer, you may not be a legal expert, you may not have gone to college, it doesn't matter. I will, as I'm trying to do, will make you the smartest person in the room when it comes to our Second Amendment rights, including the games that the anti-gunners play with their Ivy League degrees and their fancy credentials and all that, cool stuff they think they've got and all that great stuff, which, by the way, I have too. So there you have it. But nevertheless, they use that, in my view, to attack America and to attack the Constitution. I try to do it on the other side, and I hope I do it well. And by doing it well, I hope I train you and teach you to be force multipliers to protect our Constitution and our fundamental rights, including, of course, the most important of them all, the right to keep and bear arms. So there you have it, folks. Hope you learned a little bit something today. I'll put a link to the opinion down below if you want to check it out. Footnote 2, page 87. And make sure you follow me on X at 4 Boxes Diner. And we will see you again very soon, I hope, here at the 4 Boxes Diner.
Orders up. Table 2A.